Now, let's go back to that story on the Competition Commission. We have re-established that line with Kokkie Kooyman from Denker Capital. Now, we were talking about the powers that the court may have. You were speaking, Kokkie, about the grounds for overreach, and you were saying that you were thinking that the court surely should have jurisdiction over international banks as well.
Yes, I'm glad you heard that, and apologies for, the bad line here. But you're quite right. I think definitely the courts here will have jurisdiction over foreign operators, or foreign banks in this case, operating in South Africa, although it is obviously, when you talk on the case of currency manipulation, as it is stated, then, where does the manipulation take place? Does it take place in New York? Does it take place in London? Does it because it depends on obviously the clients, of which one of them would have been most probably a South African client. But still, I would think, because it's the South African currency, our courts would have ability to judge on whether that is manipulated or not. And even so, I think the international courts on the other side would agree with that, would also take up that case. But I think it's more a case here. What surprises me of Competition Commission going ahead on this again is the fact that a case was thrown out on grounds of lack of evidence. So that means hopefully the Competition Commission have done more homework and uncovered more evidence, because else, the case will just be thrown out again.
And, that was leading to my next question, to ask you about that. It wasn't just also the grounds and of overreach and the matter of jurisdiction, but also the matter that it seemed that the Competition Commission didn't have a solid and strong enough case for the courts if there was lack of evidence in some of the cases. Do you have confidence then that when the Competition Commission does then approach the Constitutional Court, that they will have a more stronger case?
One would hope so. I mean, in the end, they are using taxpayers' money. It's you and me working hard and paying taxes, and they're using that. So one would think that they have learned. And look, in the cases of Standard Chartered, and before that Citigroup who did plead guilty, we don't know how much evidence they did give to the Competition Commission, and whether they used that to further cement or build the case. But what I've heard so far, and remember, we still not have access to all the information, everything that I've heard and read points that it is going to be very difficult for any commission to prove manipulation of a currency over a period of time, and specifically with the overarching objective, as the court said, that to change the price over that long period of time. Again, if they attacked individual cases of, let's say, a transaction taking place on Monday X of that month on that year, with this bank colluding with that bank, and they have got verbal evidence of telephonic evidence of or email correspondence that proves that you can show that there was a transaction. But to make a case that this was systematically done over a longer period of time, I think it's going to be very, very difficult.
We've already had two banks who have paid a penalty, so there's some sort of an admission from the sector as well. And of course, when the matter was taken to the tribunal court as well, the competition tribunal, there were also banks who were pleading for leniency, which also brings into this thing of admission. If we're saying that the courts are talking about jurisdiction, are we saying that should there be a case here, as difficult as it may be to prove, that they could just get away with it because of the jurisdiction matter?
Yeah, I think, and that is my non-legal opinion, but I think if the Competition Commission, and I think, again, reading the case again of what the court said, that the phrasing of the original case was poorly worded. And if they had come with a case not of trying to prove collusion, but of individual transactions, then I think there would have been a stronger case, because I'm sure there are cases, and I'm sure they have evidence of cases where individual traders will have agreed with others to on a price, whether that is fixing and whether there was a loser and a winner, but there would have been. But I think the mistake they're making is of an overreaching of a long-standing agreement to systematically do that, and I think that is, in my opinion, where the Competition Commission has gone wrong. So, and then secondly, I think, and again, from the outside, that I cannot imagine, with all my interaction with the banks, that the bank managements were aware, if these transactions took place, it would have been individuals within the banks who would have done these transactions. And so that is a much more difficult case. Well, it's an easier case to prove, but it's not a case against the banks. Then you've got to prosecute the banks as employers of individuals. But again, unfortunately, we haven't got all the information, but that is my opinion.
Mm. And, the Competition Commission will argue that, they are confident that this is systematic, that they do have evidence. They ran this investigation over a period of about 6 years. So while I hear you saying, it will be difficult for them to prove an overarching case, they seem pretty confident that they do have a strong case, and they will not rest, as they've said, until this matter is resolved.
Yeah. Look, I'm impressed for the fact that they come back, so they must be confident. But, I can only go on the words that of the verdict when the court came to its conclusion, that they said, the evidence that in fact, the exact words were the cases were dismissed on grounds of a lack of evidence. And, so obviously if they've got new evidence, or the evidence they had wasn't presented properly, then we've got a different case. But they'll have to, when going to the court, will have to definitely prove that they now do have the evidence.
And since this news has come to light, what would you say some of the ramifications have been for the banking sector as well? I mean, the trust element as well must be diminishing.
Yeah, we've seen overseas as well. There are often cases like this, more serious cases against bankers, when there's money laundering involved, when the authorities uncover that the bank systems weren't good enough to highlight cases of money laundering, money and others being passed through the bank by one client to another without being flagged to the authorities. Now that investigation, even by the authorities, often takes, and I'm thinking of cases like Swedbank in Sweden, ING, Raiffeisen in Austria, it took like 10 years before it came to a conclusion, before there was sufficient proof, and even then the fine isn't actually that much. So I think in this case, I think there's going to be a lot of time that runs, that goes, that passes, and in the end the ramifications of the banks will be, in my opinion, especially also because it took place long ago, up to 2013. I think it's basically not a point to worry for the banks or the investors.
Okay. Well, thank you so much for your time. We will be keeping a close eye on that story as it develops. Now, that was Director and Portfolio Manager at Denker Capital Kokkie Kooyman.